So welcome everybody to LSE, to the law school. If you haven't been here before, it's great to see you. I'm Dr. Luke McDonagh. I'm going to introduce my colleague Mark Husovec in a moment, who will introduce our wonderful speaker in the panel. I just wanted to take a moment to explain who Professor Bill Cornish was, for maybe there's one or two people here who aren't so familiar with him. So Professor Cornish was a professor at LSE for more than 20 years, and he essentially founded the subject, the academic teaching of intellectual property law in the UK at LSE. He taught the first master's level subject in the very early 70s, and we're very proud of that contribution that he made. He obviously contributed a very fine textbook, which is still in print. He passed away a few years ago, and we set up this lecture series with his widow's permission to honor his memory and to celebrate others who followed in his footsteps and have been contemporaries with him. So in the first year we had Professor Jane Ginsburg, who was a close friend of Bill Cornish. Last year we had Professor Caroline Ncube, who was a former student of Bill Cornish. And we're continuing the tradition with today of speakers who stand in that tradition of excellence in intellectual property. So welcome to you all. I want to give a special thanks this year to Martin, who's done the majority of the administrative work to get this event together. We take it in turns from year to year as a kind of tag team. And so I'm very grateful to all the work that he's done. I'll hand over to Martin now.
Thank you so much, Luke. So welcome, everyone. It's great to see so many of you. So before we start, I'd like to say a couple of things. So the event is being recorded, which means that if you don't want to be on record asking a particular question, then wait for drinks. I guess that's a simple advice. The structure of today's talk is, first we'll have our speaker deliver her lecture. That will be followed by two comments by our two colleagues, Professor Andrew Murray and Martin Kretschmer. And then we have a Q&A. Possibly people online can also ask questions. So hello everyone online. Feel free to ask in the chat. I'll try to follow that. And after that, when everyone is exhausted, we try to resort to drinks. And that's it. So that should be your nice copyright evening tonight. Okay, so Luke told you about the series. Now I'd like to tell you a little bit about our today's speaker. So our today's speaker, and we're extremely proud that Pam has accepted to join us here at LSE, is Pam Samuelson, who is known in the community as Pam, simply Pam. So Pam Samuelson is the Richard M. Sherman Distinguished Professor of Law and Information at the University of California, Berkeley. Wikipedia says that she's a pioneer in digital copyright law, but we all in the community know she's essentially a legend in IP. She has touched so many different areas of IP and influenced them in subtle or less subtle ways that it's even difficult to recount. She has been at Berkeley for almost 30 years now, which is exactly how many years Bill Cornish spent at LSE. So I see Carl's there. She was publishing about IP at a time when Bill was obviously publishing, but there's one particular topic where they have met, not just physically, but also intellectually, and that's the question of copyright protection, which she will talk about today. A couple of things about Pam before we start. For those of you who don't know, so Pam is really a thought leader in IP. She organizes highly influential events at Berkeley almost every year. She's also founder of Authors Alliance. She's on the board of EFF. So EFF, probably those of you in tech law space are quite familiar with the organization, and is on advisory boards of many important NGOs like Electronic Privacy Information Center, CDT, and Public Knowledge. We're extremely happy to have Pam with us today. And we're also happy that our two commentators, Professor Andrew Murray, our colleague here, and Professor Martin Kretschmer from the University of Glasgow, also our colleague, visiting professor at LSE at the moment, accepted to provide some comments on Pam's lecture. So, Pam's lecture is entitled Reflections on the Evolution of Software Copyright Law since 1980s. I can tell you, I've seen slides that you're in for a treat, not just in terms of the details and evolution, but generally thinking about IP and how IP evolves and all the problems underpinning, because copyright is just one of the examples of the broader problems. Okay, I've said enough. With that, I would give over to you, Pam, and thanks so much for joining us.
You know his face. I only met him a couple of times, but he had a lasting impact on my work, and so I'm going to talk a little bit about that. I think he would be pleased to see how the law of copyright has evolved over time, and I'm here to tell you the part of the story that he can't be here to tell you. So I want to start by thanking Luke and Martin for giving me the chance to put this lecture together and to share with you some thoughts that I have. And because my interactions with Professor Cornish were about software copyright, it seemed like the only thing I could talk about that would really would show a kind of personal connection to him would be about software copyright law. I'm going to talk a little bit about what it looked like in the 1980s, which is very different from what it looks like today. I'll talk a little bit about how some developments in the U.S. case law resulted in, at least in the U.S., software having a relatively thin scope of protection, and the SAS versus WPL case was actually a test case about, are you going to go in the broad protection, or are you going to go in the little bit narrower protection? And this was a place where Cornish and I had similar thoughts, and so again, I'll talk a little bit about that. I think many of you know the saga about the UK case, the CJEU decision, and so forth. What you may not know is that SAS just didn't give up. And so the SAS filed a virtually identical lawsuit in the US, first in Tennessee and then later in Texas. And so the part of the story that you haven't heard before is the part of the story that I'm going to tell as we go through this. So I don't have to tell you how incredibly influential Bill Cornish was in the field of intellectual property. He had a wide-ranging of topics that he discussed, and only a really teeny part of his oeuvre was about computer software. And so I just happened to have a connection with him in that respect. And so I'm just going to say, I met him first at an annual ATRIP meeting. This is an annual international conference about the teaching and research in intellectual property. It was held in George Washington University Law School back in June of 1988. And Jerry Reichman, a professor at Vanderbilt Law School, Bill Cornish and I were on a panel about software and what to do about intellectual property protection. Now, I had written, I think the reason that I was invited to give that talk at that particular panel is that I wrote a paper called Conti Revisited, the case against copyright protection for computer programs, basically saying, look, I know that you guys think that software is a literary work, but it really is a virtual machine. And we don't protect machines by copyright law, right? That's just not what we do. And also, the things that we protect with copyright, generally speaking, disclose their contents to the world, and software basically mostly keeps that hidden away, and so it just doesn't match what copyright really is about or should be about. And so I endorsed a sui generis form of intellectual property protection for computer programs. Jerry Reichman presented a work in progress at the time about software as applied scientific know-how. And again, copyright law doesn't protect scientific know-how. It's just not what our job is, okay? We're supposed to be about expression of authors, etc. And so he basically suggested that, well, if copyright is going to be used for it, it should have a really thin scope of protection so that the applied scientific know-how doesn't come within the scope of protection. And the green paper by the commission about what to do about computer software, should we do copyright, should we do sui generis, that had just been released, right, a week or two before this particular panel at GW. And so we had a kind of lively conversation about it, but of course what happened after that was that the commission opted for the copyright thing, but I'll come back to that in a minute. But in 1980, at the recommendation of the National Commission on New Technological Uses of Copyrighted Works, known as CONTU, the U.S. Congress was persuaded to amend the 1976 Copyright Act to extend copyright protection to computer software. But it said nothing, and it held no hearings about what the scope of protection should be. And all we had was the CONTU report, which, let me say, my CONTU revisited paper basically said, the people who wrote that report don't know anything about computer programs, okay? Because they misrepresent, they lie about some things, and they don't understand the most fundamental things about what computer programs are. So me and CONTU, we have not ever agreed on anything. Anyway, so at the time, 1986, right, this is 1988, there was a decision by the Third Circuit Court of Appeals which is kind of like Pennsylvania, essentially, the Whalen versus Jaslow case, because CONTU provided, and Congress provided no guidance whatsoever, they said, oh, well, copyright protection is available for all of the structure, sequence, and organization, or SSO, of computer programs, and to the look and feel of computer programs. That was actually IBM's position, right? IBM actually did an amicus brief in the Whalen versus Jaslow case, arguing for SSO and look and feel protection, and said interfaces, right, of computer programs are part of the structure, sequence, and organization of computer programs, and therefore should be protectable by copyright law. And the Whalen decision said that everything about a computer program, except its general purpose or function, is protectable expression unless there's only one way to perform that particular function. The Whalen decision, so the US copyright law has a statute that says, in no case does copyright protection for a work of authorship extend to any idea, concept, principle, system, method of operation, procedure, or process. And the Whalen decision said, oh, we don't have to think about that. That just means that the idea, expression distinction, and as long as something's concrete and not abstract, then it's within the scope of protection. And I was like, so my first line of my first article on that particular decision said, good software engineering practices are now illegal in the United States of America. And so I was on the warpath about this case for 6 years. And unfortunately, at the time that we were at this ATRIP conference, there had been several courts, basically, oh, you know, the Whalen court, oh, they went into 30 pages of all this blah, 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 blah. Why should we have to rethink that? Because, hey, you know, Third Circuit Court of Appeals, we'll just follow it. And I was just like, oh, this is so bad. I was just beyond myself. Anyway, so in November of 1988, Cornish actually, as maybe in part as a result of the conversation that we had in June, wrote an article for EIPR about interoperability and said, hey, there's this stuff like software interfaces. It's not just the expression of a program. It's not just like the story of a novel. It's basically a lock. And do you want to make copyright into a system that protects locks so that everybody has to basically license from that particular interface designer, or they can't interconnect. And what's that going to do to the software industry? That was something of concern to him. And so his article basically said that these software interfaces should be outside of the scope of copyright protection to enable competition in the software industry. And then a year or so later, 2 years later, he wrote another article, because at the time that the commission was trying to figure out what to do about decompilation and what to do about interfaces, the question about whether or not it would be a violation of the Berne Convention to create an exception to allow interoperability and to allow decompilation that would enable that particular thing. And so they argued, oh, it would flunk the three-step test, and therefore it would be a treaty violation to do that. And so Cornish basically said, actually, let me take you through the exceptions and also the three-step test, and it explained why decompilation provision in the proposed software directive satisfied the three-step test, and that removing it would be harmful to competition. Right, so he made these interventions, and that was actually right at the cusp of the time when the commission was trying to figure out what to do. Obviously, in 1991, there was a decision that we had that led to the adoption of the software directive that more or less was still in place, albeit a new iteration of it. But it was so important to sort of decide copyright or sui generis. And everybody but me recognized that if you wanted to get international protection for software, that trying to get it under the Berne Convention would mean that all of a sudden you have global treaty to cover this thing. And of course, the TRIPS agreement in 1991 was in the process of being formulated, and the TRIPS agreement was another opportunity to put a provision into the TRIPS agreement that would say software should be protected as a literary work as a matter of copyright law. And so it was almost inevitable that the European Union would adopt this. But I think an important thing to recognize is that in the 1960s, the Commission had experience with IBM, which was then the dominant player in the mainframe market. So developers would try to do a compatible product, right? A peripheral that would basically interoperate with one of the IBM systems. And they started introducing them in the market. What happens is IBM changes the interface, and when you change the interface, the European product just turned out not to be compatible, and therefore excluded competitors from the marketplace. And so the Commission basically said that's an abuse of dominant position. So the competition authorities in the EU were kind of aware that that IBM was still a dominant player in that particular market, and if you wanted to be able to create a software industry that's based in the European Union, that you basically needed to say that interfaces should be beyond the scope of protection, and if decompilation is necessary in order to enable the access to interface information, it should be okay. So I think the software directive was influenced by that experience, and also there is a provision in the directive about essentially running the lawfully acquired program to study the operations should also be lawful, and so re-implementing those functions. And the European Commission also articulated that program languages, and algorithms should not be protected by copyright law, at least to the extent that they were ideas or principles, and I'll come back to that in a minute. Now, while that was happening in the EU, things were turning in the US. So in 1991, the year that the Commission basically finally published the software directive, a lower court in the Computer Associates v. Altai case basically said interfaces needed for compatibility with another program are not within the scope of protection that is available to computer programs, and it announced what I'm going to call the AFC test, I'll come back to that in a minute, and to displace the overbroad Whalen versus Jaslow, okay? And took the Whalen versus Jaslow case to task in a number of respects, and basically criticized it on about half a dozen grounds. And then within a year or two after the Altai decision came out, pretty much every appellate court in the country adopted the AFC test and the filtration that I'll be talking about in a minute, and Whalen more or less dropped out of the market in the software copyright space, at least until the Oracle v. Google case, which I'll come back to. Sega versus Accolade case was another case that was highly important. Again, this was actually a case in which Accolade essentially made video games. And the video games originally ran on other platforms, but the Sega platform was at the time extremely popular with especially kids. And they said, we want to make our games able to run on the Sega platform. So they talked to Sega and they said, you know, we'd like to do this. And they said, well, okay, we're willing to license you on these kind of terms. And Accolade said, no, those terms are unacceptable to me. And so Accolade went ahead and decompiled the Sega platform software and some of the game software, and the Ninth Circuit Court of Appeals decided that decompilation for a legitimate purpose, such as getting access to information necessary to create a compatible program, that actually is fair use as a matter of law. Now, the trial court in this case actually said, no, completely terrible. It's because there was a theory, and again, IBM was behind this one too, that by sending my program out in machine executable form, I'm using it to protect the trade secrets. And so if you reverse engineer by making copies of the program in order to get access to trade secrets, that makes you like a bad guy, because the reason that we put it out in object code was so that you wouldn't be able to get access to it. So it's basically stealing, not only making copies of our software, which was copyright infringement, but it can't be fair use because you're stealing my trade secrets. And so for a while, all the money in the world was on the side of IBM on this one, and some of you who know the debate about the software directive here in Europe know that IBM basically was trying to beat up all of the people who were drafting the law, the software directive here, and that's why the decompilation provision in the software directive is so much narrower than what came with the Sega v. Accolade case. Another important development was the Lotus v. Borland case, and I'm going to come back and talk about that. But this was a case in which the court, the First Circuit Court of Appeals, decided that the command hierarchy of a computer program was an unprotectable method of operating that particular computer. But the Supreme Court split on that one 4-4, and so the precedential effect of that decision was, shall I say, called into question. I'll come back to the Google versus Oracle case, but these are the main cases in the U.S. I want to talk a little bit more about the Computer Associates v. Altai case and know a little bit about the facts. So Computer Associates and Altai were competitors in the market for scheduling programs that could run on IBM mainframes. And IBM mainframes didn't all have the same operating system program. And so if you wanted to have a scheduling program that would run on more than one of the IBM things, you basically had to make it compatible with this one, compatible with that one, compatible with this one. And Computer Associates came up with the idea of creating, here's the program in terms of the scheduling functions, and then here's a little compatibility component. So instead of having to like rewrite the whole program in order to accommodate new interfaces, you could basically only change the compatibility component. And so Computer Associates claimed that Altai copied the structure, sequence, and organization of the compatibility component of the CA program, and the Second Circuit Court of Appeals rejected that. So CA had been relying on the Whalen versus Jaslow. SSO, more than one way to do it, therefore copyrightable, therefore you copy it, you're a bad guy. And so the Second Circuit instead adopted what they came to call the AFC test for software copyright infringement, which basically displaced the Whalen versus Jaslow case across the board. So the Second Circuit said, look, you should do three things, right? You should, first of all, create a kind of hierarchy of abstractions for the program, right? So the most general purpose of the program is the kind of the most abstract idea, and then the code is the most developed articulation of the expression of the program, and then there are layers in between, and then that helps you basically decide where are the similarities, right? If the similarities are all at the top of the pyramid, then that's going to get not that base. So that cannot serve as the basis for an infringement claim. The second step is the really important step in terms of the Second Circuit's analysis, which is filtering out unprotectable elements, right? So you've got your hierarchy of abstractions, and then you sort of say, well, this is actually much more particular. It's not really up here in the most abstract. It's down here. But, you know, it's an efficient design for how to achieve a particular function. Filter that out, right? Filter out this, filter out that, filter out this. And then, after you've done a full filtration, then you compare the protectable expression that's left after the filtration to what did the defendant copy from the plaintiff. And then you see whether there's substantial similarity in expression that shows an improper appropriation of expression by the defendant from the plaintiff's program. That's the three-step test that the Altai decision endorsed. And the similarities in the two programs lie primarily in what the court called parameter lists, which is basically an articulation of the interface information needed to make these two programs, or these programs, interoperable, and a list of services. And again, if you're writing a scheduling program that's supposed to interoperate with IBM mainframe programs, you're going to have the same set of scheduling functions, because otherwise Computer Associates beat you out, right? So anyway. So what gets filtered out? Again, I've mentioned already efficient program design elements. We have in the US a doctrine called the merger doctrine. Merger is basically if there's some expression in a program, but there's only a really small number of ways to express that, then the idea and the expression, or the method and the expression, merge, and they all get filtered out, right? And so the idea here was that second comers should not be forced to use a less efficient way of doing something, right? So the first person gets to do the really efficient thing, and then everybody else gets stuck with doing like inefficient things. And that just didn't seem right to the Second Circuit Court of Appeals. Also, elements constrained by external factors, and the doctrine in US copyright law that the Second Circuit relied on was what's called the sine faire doctrine, that is to say things that are common in works of this kind, or things that are constrained by external factors. And among other things that were constrained by external factors was the compatibility requirements of programs with which the software was designed to run. And then public domain elements, things that are standard programming techniques. So you just filter, 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 filter. That was kind of like what was going on, which is like, see how dramatically different that was from Whalen versus Jaslow. Everything about a program is protectable expression. No. Anyway, so Altai also had a kind of like an articulation about why a broad scope of copyright protection for computer programs was not consistent with copyright law, and also was not consistent with what would be beneficial to the software industry over time. So one of the arguments that had supported the broad Whalen test, oh, if we don't give broad protection, then people won't get rewarded for all the hard work that they did, and the Second Circuit says hard work doesn't matter. It depends on what this, the prediction that the developers will underinvest in software unless the broad scope. I don't think that's true. And then they said the exact contours of the scope of copyright protection for non-literal elements of software is unclear, but copyright may serve as a relatively weak barrier to public access, as in all the functional stuff in the software is not within the scope of protection, so you get copyright for a code and maybe a little bit more detailed structure, but not for a lot of things. Court recognized the hybrid nature of computer programs, that they were both functional and somewhat expressive, and said, this is like, you know, a square peg in a round hole, and it really just doesn't fit. So I was like, and they even said, hey, we need contour too, and I'm going, yes. Of course it didn't happen, but I was like, for a moment, I was happy. Now, you know, fast forward, of course, between the Altai decision and 2010, hundreds of software copyright lawsuits were filed, okay? And it's really striking to me that the number of lawsuits of significance in either the UK or the EU generally about software protection has been relatively small, right? So we are very litigious. You guys are like less litigious, but the SAS case was really an important milestone in not only how UK would be thinking about it, but also this was before Brexit, so how the CJEU would take a look at it. So the claim was that WPL was an infringer because it emulated the functionality and the behavior of the SAS program. And it used the SAS language with which people who had been licensees of SAS were able to kind of like make little mini programs to do things that they really liked, okay? And so the SAS users had made investments in creating these little mini programs to run on the platform. And so in order to like attract people to come to go to a different platform, you had to be able to you know, nobody's going to rewrite all their scripts in order to run on an alternative platform. So SAS basically wanted to stop that from happening, and they claimed copyright protection in the behavior of the program, in the language that SAS had created, and also in data formats. And this was, I think, important at the trial court level and also at the CJEU, that WPL did not have any access to the source code, but had studied the SAS manuals, tested the operation of the program in order to understand how it functioned, and then Justice Arnold ruled in WPL's favor, but referred some questions to the CJEU. Now, in 2011, the fall of 2011, this organization called the European Committee for Interoperable Systems was celebrating its 21st anniversary. And at part of that anniversary, they wanted to like talk about the SAS versus WPL cases, the first significant case that goes to the CJEU. And Bill Cornish and Tom Vinya, who was a proponent of and had represented some of the companies that were part of the ESIS organization, we wanted to talk about what's going to go on with the CJEU. And Cornish prepared some written remarks on content that Tom and I were planning to share with the people who were at this particular anniversary thing. And I still have a file of the Cornish material on my computer. And so I was like, oh man, I can actually share some things with you. Okay, so Tom and I viewed the SAS case as a watershed on whether the CJEU would interpret the directive to allow free use of interfaces to enable interoperability. And Cornish, in his remarks, said that there was a real danger that the CJEU would give bad answers to the questions that were posed, and this would result in copyright having tentacles far more bracing than the patent system could provide. And my talk was primarily about the strong similarities between the SAS case and the Lotus v. Borland case, which had recently been decided by the First Circuit Court of Appeals. Now, the next slide is actually from my slide deck from the talk that I gave at the ESIS event. So it posed exactly the same dilemma as a SAS case, right? You had Quattro Pro was a spreadsheet program that wanted to attract people who had been users of Lotus 123. Those people had made investments in creating macros, little mini programs, to do the very common functions that they did over and over and over again. And so in order to help the people who had been Lotus 123 users port their stuff over to the Borland program, Borland created what they called the emulation interface, and that emulation interface enabled those little mini programs, those macros, to execute effectively on the Borland platform. And it was important to sort of understand that the command hierarchy of Lotus 123, right? So, you know, we're all familiar with the little menus that we have of different commands and stuff like that. But copying the command hierarchy was necessary to enable the macro compatibility, okay? So, and Lotus was saying, hey, that's structure, sequence, and organization. There's creativity. There are many ways you could do it. So Whalen versus Jaslow, blah, blah, blah. And the district court ruled for Lotus because the command hierarchy was creative SSO. And that had the effect also of protecting essentially the behavior of the program, right? Which was called at the time look and feel, as though look and feel was like a real thing, instead of just a baloney name to be given to something in order to try to get copyright protection really broad. Okay, so a lot of games going on in these cases. Anyway, so within a month after the program that I was talking to you about, we wrote a paper basically explaining why the CJEU should rule in WPL's favor on program behavior, languages, and interfaces. They should all be outside the scope of copyright, and we were incredibly relieved when, in fact, that's what the CJEU did. So it wasn't a foregone conclusion that that was going to happen, okay? Because yes, they say, oh, interfaces and program languages are not protectable by copyright law. To the extent that they are ideas or principles, like, oh gosh, what does that mean? So you can see that you could go in a Whalen versus Jaslow direction and sort of say, wow, these aren't just abstract, these are really concrete and specific. And so it was not at all clear. And it's clear that the design of the SAS program behavior and the SAS language were creative, right? I wouldn't say they're not creative, but the question is, are they within the scope of protection? So the CJEU basically says, look, software is protectable as a literary work, but the functionality of the computer program and the programming language and the format of data files is not within the scope of protection. And it was like, hallelujah. So it's really, this was a watershed case. Now, SAS didn't give up, right? So it goes back down to the trial court in the UK and makes an argument that, oh, they just said, you know, to the extent, and we're going to still say it's not within the sort of like, to the extent that they're ideas and principles. They're more than ideas and principles, and therefore they're protectable. And lost at the UK High Court. And then it went to North Carolina, which is where SAS eventually originated. Its home state, suing WPL for both copyright infringement and breach of a license that basically says you can't reverse engineer and you can't even use it to study how the program interacts with users. And the trial court ruled against the copyright claim. SAS argued that the Federal Circuit's ruling in the Oracle v. Google case, which upheld the claim under a Whalen versus Jaslow theory, that, oh, Java API declarations are creative enough to be protectable by copyright law, and therefore you should rule in my favor. And the trial court said, nope. Now, the Court of Appeals upheld the license breach ruling. And here's a place where UK and EU law is different from the United States, because it basically says that decompilation and study, sort of running the program to study it, you can't contract around that, right? You can't make them waivable by contract. That's not true in the United States, although I can make an argument that it should be preempted by copyright law, but that's a different subject. The Court of Appeals for the First Circuit upheld the license breach claim, but vacated the copyright ruling, saying it's not really necessary, and then said, no, I'm not going to give you an injunction. So you got some money damages, that's adequate, right? And SAS still didn't give up, right? It filed another lawsuit in Texas, and the reason that they chose Texas is because in the engineering dynamics case that had been decided in the mid-1990s, the trial court had said that that the input and output formats for statistical software was uncopyrightable, and the Court of Appeals said as long as they're original, the input and output formats could be protected by copyright law. And so they thought, oh man, we can go to Texas and we can win in Texas because we're claiming copyright protection or infringement because of the use of our input and output filters. And so SAS hired the same lawyers who had won the Federal Circuit case in the Oracle v. Google case to the Federal Circuit, right? So they put a patent claim in the complaint as well as a copyright claim. The patent claim falls out of it, but that means the case goes to the Federal Circuit instead of to a regional circuit, okay? This was all gamesmanship, I'm telling you. This is mean stuff in the US, okay? Anyway, so the lawyers who had won the Oracle v. Google case before the Federal Circuit are now saying, you see, it's original, it's protected, and therefore we don't have to do this filtration stuff. And so there were cross motions for summary judgment, which means you don't have to go to trial. And the trial court basically said, look, the engineering dynamics case, which SAS was relying on, endorsed this AFC filtration thing. And so the judge basically said, I'm going to hold the copyrightability hearing. I'm not willing to send this case to a jury without knowing what things in the program are protectable and what things aren't protectable. And so asked the parties to articulate this so that the judge could filter the stuff out that's unprotectable so that the case only goes to the jury about the protectable stuff. And SAS says, this whole thing is improper. All I have to do is show original and more than one way of doing it, and therefore it's copyrightable, and therefore I win. And the trial judge basically said, look, you're not participating, right? I directed you to say filtration, and you said filtration is unnecessary, and I'm telling you it's necessary. You didn't give me what I want, I'm going to throw you out of court. So WPL basically came forward with an expert testimony basically saying, look, an early version of the SAS software, everybody agrees, was in the public domain. And the input and output formats of that particular version are pretty much the same as the ones now. So that means that those input and output formats are in the public domain. And then a number of the other things that were arguably protected were outside of the scope of protection for one reason or another. And so the judge basically threw it out. Now, this decision, I wanted the Federal Circuit, which again decided the Oracle v. Google case on a Whalen versus Jaslow theory. I was really super worried about this particular case going back to the Federal Circuit because they had mucked up the Oracle v. Google case. So I worked with a couple of other people to file an amicus brief in support of WPL, urging the Federal Circuit to affirm, and here are the kind of main terms the main points that I made, or that we made in this particular thing. And part of what was happening is that the lawyers for SAS, they're very clever, okay? They sort of say, look, this is copyrightable because it's original. And I said, the term copyrightability has three meanings in copyright law. One is a work categorically eligible for protection? Software, the answer is yes. The second thing is it copyrightable? Is it original enough to attract copyright protection? That's one thing. And then the third question is it within the scope of protection? At least many courts talk about the copyrightability in that third sense of the term, and what the lawyers for SAS wanted to do was say, oh, you don't have to worry about that scope of protection thing. All you have to do is, so they were mixing up 2 and 3 here. And so the biggest thing that happened, from my standpoint, in the Federal Circuit's eventual ruling in favor of WPL was that they bought that there are 3 ways in which that term copyrightability is used. And they ultimately upheld the dismissal of the case, and SAS didn't try to take that up to the Supreme Court. But SAS still didn't give up. Just lost again. But what it had was a judgment of $79 million from that breach of license claim way back when. And SAS wanted to be able to collect on it. And SAS basically was, WPL was fighting back. Basically said, I don't, So it got actually an anti-clawback order from a UK court telling SAS to stop harassing WPL customers. But in 2020, the Court of Appeals affirmed an injunction forbidding WPL from acquiring new customers in the US until the 2014 judgment was paid in full. Is that interesting? So this is a part of the story you guys didn't know. Okay. So there's fact similarities now between the SAS case and the IBM case, which was just recently decided by not the High Court, but some other kind of court that I don't know how to pronounce your name. Anyway, so it's like the same basic argument, right? The SAS, WPL got access to educational versions of the SAS software, and eventually to a full version of the software through a third party. The goal was to analyze the behavior and modify WPL's software to make it more compatible. And the SAS license forbade reverse engineering and also what they call non-production uses of the software. And non-production means that you run it through its execution and see how it behaves, and then you learn something from that, and that causes you to do something. Basically the same fact pattern here in the IBM case, and the court basically said breach of license, and also, hey, you conspired with other people to breach that license by gaining surreptitious access to it. But in the SAS versus WPL case, they said the part of the software license that says that you can't reverse engineer was unenforceable as a matter of UK law, and so the decision by the court here in the UK seems inconsistent with the decision in the SAS case. Now, more general comments before I hand it over to others. So some of the hardest fought lawsuits in the software copyright area have raised what we call the two-way compatibility, right? So I want to write a program that essentially will allow people who've written programs for another platform to run on my platform. So IBM sued Fujitsu, Apple sued Franklin, Lotus sued Borland, SAS sued WPL. Many of the cases and many of the kinds of compatibility issues that arise are basically one-way compatibility, right? So Accolade wanted to make its games able to run on the platform, right? That's one-way compatibility. Now the Sony versus Connectix case in the US is an example of two-way compatibility, right? So Connectix emulated the functionality of the Sony PlayStation game so that PlayStation games could run on the Connectix platform, not just on the Sony, platform. And of course, way back when, the European Commission challenged Microsoft for denying access to interface information so that Sun would be able to make a program that would allow things that were written for running on the Microsoft platform to run on the Sun platform. And the EU General Court upheld the two-way compatibility under the European, or the software directive. And so that to me is like an example where, you know, two-way compatibility is something that there's a legitimate interest in, not just one-way compatibility. Now, the interesting thing about the way the Supreme Court decided the Google versus Oracle case was to say that programmers, there are like something in the neighborhood of 6 million Java programmers in the world. They all spend a big part of their lives learning to program in Java and learning to use what is technically called declarations from the Java API. And so the Federal Circuit both rejected the uncopyrightability argument that was made in 2014, and then later rejected the fair use defense that Google was making. But the Supreme Court said that Google had made fair use of the API declarations to enable Java programmers to use their skills to write apps for Android, and characterize the declarations at issue as interfaces between method calls. I'm a Java programmer, and in order to get this particular implementing code to perform a particular function, I have to use the Java API declaration. So Oracle did not claim copyright protection in the method calls, and the implementing code was independently written by Google. It just was re-implementing the interface between the two things because that was actually sort of important for Java programmers to be able to do it. So it was a compatibility case, but a different kind of compatibility case than we've seen in the past. And just so you know, IBM, which back in the day was like copyright protection for interfaces, copyright protection for interfaces, they filed a brief, an amicus brief with the Supreme Court saying, oh, interfaces should never be protectable by copyright law. It turns out you want them to be copyrightable when you are the dominant firm, and you don't want them to be copyrightable when other people are the dominant firm. So IBM is known to change its position on some of the copyright and patent issues. So concluding thoughts, I think the European directive was actually better informed about software than the US statute, which, as I said earlier, was Cantu's fault. They basically didn't understand what they were talking about. So the idea of excluding logic, algorithms, programming languages, and interfaces was actually sensible, right? They knew what they were talking about, whereas Congress didn't know anything about what it was talking about when it passed those amendments in 1980. And it mattered that WPL had never had access to the literary expression. I think the SAS case turned on that. And US courts have had to like invent a whole bunch of different doctrines to try to say, oh, interfaces actually are protectable by copyright law. So sometimes they rely on this exclusion of procedures or methods of operation. Sometimes they rely on the merger doctrine, sometimes on the Santa Fe doctrine. And the Supreme Court, just to add a little bit of spice to the whole thing, said fair use, right? So we reach the same result, but by kind of like more circumspect way. Okay, I think it's actually worth noting that although we use different terminology, that for the most part, EU and UK and US outcomes have been pretty similar. And again, I'm not going to go through the details, but it does seem to me that that's actually noteworthy here. Okay, you need to understand, back in the 1980s and the 1990s, as hot and controversial as generative AI is now, that was what scope of protection was about back in those days, okay? You just can't believe how bitter and how personal and how controversial and how much they basically try to beat you up if you try to say that decompilation was fair use. Carla Anderson Hills, which was at the time of the software directive being pending, she was a member of the IBM board of directors, and she was also the US trade representative, and she personally attacked me for how dare this person argue that decompilation. I'm going like, how can it be copyright infringement to read the text of a copyrighted work? So anyway, I wish Cornish was still with us to help us through the what to do about generative AI. I think it's fair to say that at the time that the text and data mining exceptions were adopted, generative AI wasn't what was on their mind, but they have to deal with that now. And again, what we need is like sensible people who want the world to be a better place and who can figure out ways to kind of accommodate the interests of the developers, of the people whose works are being used, and the public. And we are in for a long ride on this one. So thanks very much.
Thank you so much, Pam. I guess Andrew, please, would you like to go first?
Yeah, I'm quite happy to.
Please. Professor Andrew Murray.
Right. Yes, I've been set the small task of following Pam Samuelson. Thanks to Pam for the wonderful and engaging lecture. It took me back when I started to teach this and research this. I would read academic papers by Mark Lemley, and Pam Samuelson, and Bill Cornish, and I would read the case decisions of Robin Jacob, and I always enjoyed reading most of these. And I know that Bill would have loved to have been in the audience, to have listened to this, and he would have had his questions ready. And they would have seemed simple questions at first, but quickly you would realise they had a depth to them that were not immediately apparent, and that the answer you'd confidently prepared was not quite sufficient to get to the heart of the question after all. So let's first acknowledge that software was never meant to be protected by copyright. Computer hardware was originally supplied with software pre-installed and maintained by the hardware manufacturer in the way that you buy an e-reader today from Amazon. When IBM first unbundled software in 1969 in response to Department of Justice antitrust investigation, interest in how to protect this new product peaked. Software was clearly a functional product, not an artistic or creative one. The obvious method of protecting software was therefore by patent. However, the courts moved quickly to reject the extension of patent law to software. In Gottschalk and Benson, the US Supreme Court ruled that a process which converted binary coded decimal numbers into true binary, which is valuable for software development, was not patentable. The court left the door open to patentability. Justice Douglas, in giving the opinion of the court, said that this decision should not be seen to deny patentability to all software. and noted it may be that the patent laws should be extended to cover these programs, but that this was a policy matter which we are not competent to speak, i.e. Congress, get your arse in gear. The Supreme Court revisited the issue 6 years later in the case of Parker versus Fluke, and here the court found the addition of a new software-based system to calculate safety limits in a catalytic conversion process was insufficient to qualify the process as a whole for patent protection, the only novelty being in the software. Although the later case of Diamond and Deere limited some of the worst successes of Parker, the movement in favour of copyright protection for computer software rather than for patents or for sui generis protection had been set in the mid-1970s, and not just through this series of cases, but as Pam has already said, through key legislative developments such as Congress's stated intention to extend the 1976 Copyright Act to cover computer software and the exclusion of software from patentability per se in the European Patent Convention, which came into effect in 1977, and through the UK Patents Act 1977 as well. A decision, it seemed, had been made. Software would not be patentable, and also following the failure of the Galby proposal to Congress in the early 1970s, it would not be offered sui generis protection. This left copyright, and as might be expected, and as Pam has already said, in December 1980, the US became the first country to formally extend copyright law to computer programs by amending the 1976 Copyright Act to include programs. So by the time Pamela met Bill in 1988 at ATRIP, software copyright had become embedded in common law countries, if not quite yet in the EU and in civil law countries. Following a slightly surprising outcome in the initial hearing of Apple Computers versus Computer Edge in the Federal Court for New South Wales, Australia had passed the Copyright Amendment Act 1984, while the UK had passed the Copyright Computer Software Amendment Act 1985, finally and formally bringing computer software within the protection afforded to a literary work under the 1956 Copyright Act, a protection which was later extended by the Copyright Designs and Patents Act 1988. But it was all a lie. It was a legal fiction. Superficially, software could be viewed as a literary work. It was written in code and recorded. You could read the code, and if you were literate enough, you could understand what the computer was being instructed to do. In the absence of better alternatives, sui generis protection or patent protection, we had settled for third best. We had looked at copyright and we thought, you'll do. However, as anyone proficient in the law of copyright understood it, it really didn't do. Software, in essence, is a functional product, not a literate one. Software is recorded, be it on disk, hard disk, server, EEPROM or anything else, is valueless unless run. So whereas the economic value of a James Bond novel is in the protected element, the words on the page, which you read directly, the economic value of software is not in what it says, but in what it does. It is its operation which is valuable, not its interaction. This has over the years caused countless problems for courts. If the value of software is not actually the code, but in how you use or experience it, how do courts protect this expressive value? Well, drawing on the traditional principles of literary copyright, that what is protected is the literal expression, not the ideas, nor the application thereof. This is what led to the ill-fated dalliance with so-called look and feel, which Pam has spoken about, on both sides of the Atlantic, in cases like Whelan versus Jaslow, as you've heard, but also in cases like John Richardson Computers versus Flanders and Ibkos versus Poole. This, though, was the creation of a fiction on top of a fiction. The first fiction was that software was a literary work, the second that we could determine the value of protectable elements of how we use that work. Secondly, software is inherently interoperative. The value of software is rarely contained within an individual piece of software. A word processor needs an operating system needs a BIOS. Computers are complex ecosystems with multiple points of interoperability. The fact that Ian Fleming had written the character of James Bond did not preclude Tom Clancy from creating Jack Ryan or Sam Rolfe from creating Napoleon Solo. They did not need Fleming's permission, as Fleming's copyright only extended to his James Bond works. He could not control access to the wider espionage literature. However, in a real sense, designers of key operating systems such as Apple or Microsoft are gatekeepers of their operative universe. See the current litigation in both the US and the EU on the Apple App Store. As Pamela has already covered, this was something Bill wrote about in 1988, where he spoke of locks on access. So, as you've heard from Pam in this excellent Cornish lecture tonight, this unstable tower built in the 1980s came tumbling down brick by brick in cases like Computer Associates versus Altair, Sega versus Accolade, and Lotus versus Borland in the US, and through the SAS series of cases in the UK, EU, and US. As Pam has outlined, the work that she did and Bill did in the years following these cases have been vital in ensuring that software copyright did not become all-powerful. The SAS versus WPL cases, in particular those in Europe and the UK, could have gone horribly wrong. The 2012 EIPR article hits so many of the concerns that people felt at the time. The idea that language itself could be protected, the structural supports for expression rather than the expression. And as Bill, Pamela and Thomas Vineyard expressed, the risk if the court made the wrong decision to extend copyright was to take us well beyond expression into values or ideas. So I'm actually going to quote a little bit from that very good paper. Should software copyright cover the same technical ground as patents by protecting functional behaviour without any copying of substantial portions of code? To extend software IP so far would provide a shortcut to gaining exclusivity over technical alternatives that behave in the same or similar way to software already available. The exclusion of competition would necessarily be far wider than through software patents. The copyright would come into effect simply upon writing the program. It would be infringed when a third party produced a program in its own code which functioned in the same way, whether or not it was written to interoperate with the first product. In truth, rights over functional effects of machines should never be accorded on an unregistered basis. That's important. Copyright is not written down, unlike patents, or unless in the US you want to enforce it, but we're talking from Europe here. So following the CGEU SAS outcome and that of the High Court, attempts by software designers, including SAS, to use licenses as a substitute for copyright protection have been largely kept suppressed and under control, as Pam has covered, although the recent LZ Labs case might suggest it is not yet the infamous Norwegian blue. So what would Bill have asked? Well, throughout his work, you see very important to him are elements of competition and access and making sure that competitors can gain a foothold into the industry. I've no idea what he would specifically ask in response to a lecture like this, but given that and his keen interest in contemporary developments, I think he would have been really interested in the last slide and generative AI in software design and development, and to ask, does it make any difference how we should think about software copyright? Maybe something like, given the evolution of AI and software development practices, should copyright law adapt to balance developers' rights and interests with the fostering of innovation and interoperability? Maybe something like that, I'm not sure. But I'm sure that everyone in the audience has their own questions. So I just want to end by saying, again, thank you, Pam, for such a thought-provoking lecture, which reminds us all of Bill Cornish as well. So thank you.
Thanks very much, Andrew. And Mark. Professor Martin Kretschmer, University of Glasgow.
Okay, so you had already two opportunities to hear the history of software copyright. It's a privilege to be here with Pam on the same stage. So I will retell the history once more, but perhaps through the lens of what we learned from it. So lawmaking for technology, what are the pitfalls, and how the interventions you made, Pam, in the US, which dragged copyright law back into a more patent space, with a focus on competition, interoperability, market access. What do we learn from that for lawmaking in the last slide you have now up here? And yeah, I think we all agree that software is a very poor, odd candidate for copyright law. You know, yes, we can read code, but that's not why we are interested in code. I mean, some programmers may love the beauty, but most of us, you know, we treat it as a machine. So that's why one sometimes talks about this software as text or machine. So if we think about how we dealt with this at the time, the chief reason was, I think, international political economy. You know, by using copyright, we could slot it without further agreements into a global system. And after many discussions, that seemed to be, you know, it's a sleight of hand, but it worked very effectively, but then ended up, you know, with a lot of problems in the industrial organization and operation of these markets. And so the solution was in the US, and I assume in some ways also in the EU, the solution was litigation and case law development. And by developing concepts within copyright law, which were in some ways not there before. You know, normally copyright infringement scope is really not operating with the concepts, you know, I wouldn't say invented, but pushed in the US. And in many ways, the EU did not go the litigation route. It learned a little bit by introducing the decompilation and interoperability provisions into the 1991 software directive. So that would be a more, you know, not a different strategy, I assume, in technology. It would be more tailoring a law to a technology. But then we have still got the same problem that we may end up with technological language. So if we make substantive law for new technology and we use the terms of the technology, we create potentially a trap. And I've tried to think of a few examples how that happens, you know, in other contexts. So in the European context, I came up with 3 quick examples. So one is from the e-commerce directive, 2000. So we have the provisions here for mere conduit caching and hosting. And at the time, they were driven essentially by browsing, using, you know, the web. But they didn't really think about search, and so web indexing doesn't really easily fall under the definition here. So what happened here, you know, again, you've got a technology-specific definition, which then I assume either through case law or through practice was accepted to extend to web indexing. Again, we'll come back to this in the end. Another example I could think of is Article 17 and Article 2 of the Copyright and Digital Single Market Directive. You know, so we created this new entity of online content sharing providers. Essentially, we created a provision which was defined in law to make YouTube primarily liable. Okay, so you had a law which was written more or less, you know, for a couple of instances, and then they had to give a long list of specific services to which it doesn't apply. So that's again a strategy of lawmaking which I think carries obvious dangers. And the third one is the one we have just up here. Text and data mining. It was, you know, conceived as a privilege for data analytics. It was not conceived in mind for, you know, generative AI, and it certainly also wasn't conceived with the idea that you would use software as training material for generating new software. I want to come now to I assume, puzzles to look at the context of machine learning. So the first one, okay. So let's look at open source software. So it's made available under, let's say, under GPL license, and it therefore has the viral provision of that derivative works have to be made available under the same terms. So two puzzles. So the first one, is that an opt-out? secondly, it is what comes out of the machine derivative work. So these are two things where we haven't really had a lot of literature about, and they may be suitable for the first strategy. So you could probably ask a question to the CJEU, or you could litigate on that, and they'll probably come up with something. You know, either it's an opt-out or not, or either it's a derivative work or not. And again, you could invent new concepts which may push the law in the direction which we may need for societal grounds. And then the second example I could think of was, okay, so again, open source. So let's say, so many of the advanced models now don't need a lot of compute to run them. So you know, you can run DeepSeek R1 or Llama 3 on your laptop, and within a week of DeepSeek being released, there was guardrail stripped versions available on Hugging Face. Okay, so within a week, all the political censorship of China had disappeared, but also I think a lot of the safety guardrails as well. So yeah, within a very short period of time, you had this kind of thing out there, which not clear who did it, but out there under a particular license. So then you download it in this country from a server, Hugging Face, I assume, which they're using now Amazon Web Services. I don't know where the actual data center sits, but they're certainly not sitting in the UK as a data center. So we then have here our laptop, and we have a code-generating machine on our laptop. So where do we actually start here to analyze how to use the concepts we have now in law to come to a societal solution? So I should just end on this puzzle, but I would be interesting to hear from you, Pam, from your experience, as a participant in the development of the law. How do we approach, as a society, but also as lawyers, lawmaking for emerging technology? Thank you.
Okay, thank you so much, the two commentators. Now I'd like to give first Pam the chance to respond, and then in the meantime, please think about your questions, and we'll collect the questions from the audience here present first, and then we'll see if there's something also live. So, Pam, please.
Great. So thank you both for comments that I think nicely supplement things that I was trying to convey. I didn't talk about the patentability cases and how they were important actually in the story, because at the time that the Gottschalk versus Benson case was before the Supreme Court in 1972, IBM had already decided that copyright was its big friend, okay? And so it filed a brief along with a couple of other of the big software companies, or mainframe computer companies at the time, and they said, oh, algorithms shouldn't be protectable, there are mathematical expressions, but copyright's available. And at that time, the Copyright Office had decided to accept registration of computer programs under what it called its rule of doubt, as in, I doubt this stuff is really copyrightable, but I'll issue you a certificate anyway. And IBM was, unsurprisingly, the most frequent of the registers of the software copyrights. So they have basically planted their thing, and so then when they were able to get, oh, you don't need patents, algorithms, mathematical things, oh man, that shouldn't be protected, but man, software can be protected through copyright, and then the Supreme Court says that. Now, Supreme Court didn't decide. This is dicta, right? This is not like anything like the court held. But it was enough to then sort of reassure the Copyright Office, yeah, that's okay. And then, because copyrightability of software was one of the things that was holding up enactment of the 1976 Copyright Act, they spun all the new technology issues that they couldn't deal with out to this Ncube group, who then proceeded to make some decisions that were monumental, even if misguided and misinformed. So we have that. Let me tell you one story. And since John Hersey is no longer with us, I read the Ncube report very closely, as you can imagine, and the tone of the majority opinion about software was so calm and so icy cold. And then the dissent that John Hersey, the novelist, filed in the case was just red hot. And I said to myself, you know, I think there was a fight. And I wrote to Hersey, and he actually got back to me. I wrote to him through the New Yorker, because he published there sometimes. And he actually answered me. And I said, you know, I just have this intuition from reading this that there was a fight. And he said, yeah, there was. He said, I had a majority of the Ncube Commission ready to vote against copyright protection for computer programs. And then Arthur Miller, the law professor, who is chair of the subcommittee, baited novelist Hersey, caused him to lose his temper, and when he lost his temper, he lost his majority. I like to tell that because you don't know how contingent it really was. We could have gone completely the other way. And if you read the Hersey dissent in the Ncube report, you can see that he articulates extremely well, even though he wasn't a lawyer and had no legal training. He sort of expresses why copyright is going to be really not a good fit. And so anyway, I had a nice correspondence with him for a while, and I thought that was like worth sharing with you. And so another thing that I think comes out of the remarks that both of you made is that what we ended up with is sui generis within the body of copyright law, right? That we had to come up with these new concepts. So Altai essentially was the kind of the big inventor there by saying, oh, efficient designs. Oh, let's use the merger doctrine for that. External constraints on design decisions. Let's use the Sena-Fair doctrine for that, okay? So, and another thing actually that's important, I think, is metaphors. Metaphors in technology law are extremely important, okay, at least in the US cases. One of my favorite examples is that there was a big look and feel lawsuit between Apple and Microsoft, right? So Microsoft copied the look and feel of the graphical user interface that Apple had been using, and that partly it stole from Xerox PARC, but that's another story. And at one point, you know, so Apple had all these graphical user interface designers, the people who had, you know, all these degrees in art and da-da-da-da. And so he was like, oh, here's all the kind of artistic blah, 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 right? They were even named like, you know, graphic artist, kind of like. And Microsoft says, actually, this is like the dashboard of an automobile. And when the judge picked up, oh, this is a user interface between the user and the car engine, the automobile dashboard won that case, okay? Similarly, in the Lotus v. Borland case, the metaphor of a VCR, right? So, Judge Stahl's opinion for a majority of the court basically said, look, when you want to operate your VCR, you punch buttons, right? And when you want to run the Lotus 123, you punch some buttons, okay? And punching those buttons, this is just like a VCR, maybe a little bit more complicated, okay? That metaphor, boom, really important. And so one of the things that is a challenge, because as complicated as software is, generative AI is way out there. And so trying to sort of think about what are metaphors, no, but you're not going to get the first question. Okay, that's my husband.
Just provoke me with what you just said.
You are not getting the first question.
Second question.
Anyway, so, but these metaphors are really important, and I think that's something that the courts really grapple with, is the judges are not technically trained, and so to be able to like find some analogy is something that will help the courts basically. Now, the analogies can be, misplaced, obviously, but it's something that I think that technology lawyers right now are struggling with, which is how do you kind of like convey what's going on and why this is actually something that is desirable and not some, sort of like the people who are representing the plaintiffs in some of these generative AI cases want to say, this is just like Napster. It's like, no, it's not just like Napster, okay, just so we're clear. It's not just like the Office Guild versus Google case, which is about, it was fair use to copy millions of books in order to index contents and make snippets available, right? That's one that the generative AI defendants want to say, oh, that's the case, okay? So it's more like that than it is like Napster, but again, the precedents really require you, I think, as Martin was saying, you got to invent some new concepts. You got to like figure out what are kind of like reasonable balancing techniques, and you guys are going to have a different set of them than we do in the U.S. One of the things also that I think you could see from the slide that I had about all the different doctrines that are used in the U.S. about unprotectability of interfaces, we actually like redundancy, right? And so if this court uses fair use and this court uses merger and this court uses 102B, that doesn't bother us, right? Now me, I prefer to have things cleaner. So this should be merger and this should be 102B and this should be like fair use, okay? But I'm happy to have, shall I say, redundant doctrines that basically do some balancing work. So I think that's my comment.
Excellent.
So
Thank
please
you.
somebody ask a question other than my.
Thank you. I mean, first of all, I finally understand whenever I watch US Supreme Court cases why the parties come up with ridiculous analogies to technology. I finally understand it because it's a contest of the best analogy that frames the case in your favor. But because really those analogies are often really ridiculous. I don't know if you've ever have noticed. Okay, so show of hands. Trevor here, please. And then I see Martin.
Thanks very much, Pam. It was fascinating to see or to view from a different perspective the background, considering that I was involved in some of the discussions leading to the European Software Directive, and to see you putting those discussions into another context. And we could come back later about the question and the relevance of the decompilation exception, which has proved to be completely useless in practice, as demonstrated by the Microsoft and Sun case. But I was most fascinated, I think, by the way you characterised in your last remarks what we now have in both jurisdictions: sui generis protection within copyright. And I was wondering, thinking back to your original wish for sui generis protection, and the experience we've had of sui generis protection in other areas, like semiconductor chip topography, database protection, whether we haven't got actually the best of both worlds by having sui generis protection within copyright rather than having a standalone sui generis protection.
So it worked out better than I predicted. The problem is that, you know, other than the IBM lawyer who originally came up with a sui generis proposal, you have people in the policymaking community who just don't know anything about the technology, and they don't know anything about the industry, and you know, and they don't usually ask economic experts to weigh in. And so the problem is that, you know, as with the database directive here and the Semiconductor Chip Protection Act in the U.S., you know, we adopted some sui generis laws that were pretty bad ideas, you know, so things worked out pretty well with copyright. But I think it's actually important to sort of understand that the time when copyright was the most important for the software industry was in the heyday of the sort of application program time in the late 80s and through the 90s, right? That's when mass market software became a thing. We don't buy software the way that we used to buy software. And many of the software companies, especially the ones that are extremely successful, they don't rely really on copyright. You know, they actually do a lot of open source, and so there was a time when, you know, when people who were open source advocates would come to intellectual property conferences where software was being discussed, and it's like, you're the devil. Because they had basically drunk the Kool-Aid that you had to have copyright or no one would ever invest. It's like, excuse me, there's this thing called network effects that's really powerful. And, you know, the people who were doing the drafting just didn't know. Again, you know, have there been kind of difficult times along the way? Yeah, I mean, that 6-year period between the Whalen versus Jaslow case and the Altai case, they were painful, okay? And as I said, the rhetoric and the anger and the, you know, way that people treated each other, it was as though they took everything super personally. And so if you didn't agree with something, then you were like a bad person. So I'll just give you one example. I once wrote an article that I wanted to reach a copyright audience, and it was about software copyright. And I submitted it to the Journal of the Copyright Society in the US. And I didn't hear from them for a while, so I got in touch with them. I said, like, what's up with that? And they said, we don't accept articles written by people like you. Okay, I think I get that one now.
Did you interrogate what is like you?
I knew what he was talking about, which is you are not part of that. I love copyright and I love software copyright and I'm going to be a maximalist. Okay, I wasn't willing to do that. I was basically saying this doesn't fit. Okay, just so we're clear, it doesn't fit and not going to fit really easily, and we're going to have to do a lot of adaptation here. Fortunately, there was at least one U.S. case, the Baker v. Selden case from the 1880s, which was about the scope of copyright protection in a book about bookkeeping. And Baker was alleged to infringe by copying the selection and arrangement of columns and headings of the bookkeeping forms that were in his book. And what the Supreme Court said is you get copyright protection for your explanation of the bookkeeping system, but not for the bookkeeping system itself. And if you want to get exclusive rights for things like medicines and for plows and for bookkeeping systems, you need to get a patent. You can't get it from copyright. And that decision, in that Altai case, I had a brief in that case too, that decision was pointed to in the in the Second Circuit's Altai decision as the starting point for analyzing software copyright, because it was a functional writing and it had a thin scope of protection. So again, the analogy between software and the bookkeeping forms was an analogy that actually took.
And it's, I just realized at this moment when you were talking about incentives that it's such a pity that I see that Mark Shankerman, our colleague from the economics department, couldn't make it. He really wanted to come. Probably something came. And because he has done work on looking at incentives in open source space, basically showing there are all sorts of reasons why developers self-select into these projects that have very little to do with the incentives that we're thinking about in the copyright space. So, okay, I have Martin and then Bob. If that's okay, Japan. Bob is the third person. And then I'm collecting additional questions. Okay. Patrick, okay. Yes, please, Martin.
Well, thanks so much. Thanks so much, Pam, for this fascinating lecture. You totally convinced me that nowadays it's no longer a sui generis question. Everything is computer law now in copyright. So this link with the current generative AI discussion shows this very clearly. So just perhaps as a further angle from which we could look at things, and I would be very much interested in your insights into the early days of this software protection debate. You presented it as a fascinating question of legal comparative ping pong across the Atlantic, and how finally things were leveled out based on different legal doctrinal tools available. But isn't there, or hasn't there been at the time, also this strong system competition thing that we see so prominently now in the AI discussion, like the different regions of the world really trying to be the most attractive, what Martin K. would call the political economy or policy discussion in the background. It's not just about the law and making good law, but also attracting the most promising high-tech companies. And if we look at it from that perspective, there are fascinating points of comparison. So at the time, it seems that the high-tech industry was pushing for protection. In the generative AI discussion, the high-tech industry is pushing for freedom. At the time, it seems to me, or at least that's what I understood from your talk, it was particularly between the US and the EU. But nowadays, it's predominantly US and China, I think. And the EU is a bit of a bystander, trying to catch up, and the Commission saying that we want to become the most innovative, forward-looking region and so on, but it sounds a bit like a mantra. So just if you have something to share on this system competition point, what we could learn from the software protection discussion for the Gen AI discussion, that would be fascinating.
Well, I think it's fair to say that the US drove the bus on the copyright thing, and you know, Japan and Brazil and the EU considered sui generis, but the amount of lobbying, you guys think that you were the first to like deal with like serious lobbying by US companies? Believe me, you were not. Okay, just so we're clear. Okay, during the heyday of the debate, right, between more or less 88 to 91, that period of time, the amount of lobbying that was done over here was just unbelievable. And the pressure that was put on, and you know, I ended up talking to somebody who was working on the competition side about why decompilation should be something lawful, and this guy got beat up by his colleagues because IBM found out that he talked to me, and they said, don't talk to her, okay, because we don't want to hear what she has to say. And I'm going, okay. But I'm just saying the amount of bitterness. But the U.S. could drive the bus because the other countries didn't really have a growth industry. U.S. industries were basically saying, you adopt copyright? No problem, you're going to have it too. And so I think that kind of like was the rhetoric that was successful in pretty much everybody deciding that we're okay, TRIPS agreement, we're going to all do the same thing. Now generative AI, the system competition is intense again, and the U.S. companies are once again kind of trying to drive the bus. But there's a lot of resentment right now, and that wasn't as true back in that late 80s and early 90s. And so the techlash is something that I think is having distorting effects on policy making in this particular space. China, of course, is making huge investments in developing AI systems and including generative AI. But nobody I know uses any of them, and so the interest of the Chinese is more in surveillance technologies to control their population than it is to kind of like run essentially all of the systems that we all use on a daily basis. So. So I think that system competition is not there. So Peter Yu and Matt Sag wrote a paper that's coming out in the Emory Law Journal if you're interested. It's available on SSRN, which is their optimistic view about the global consensus emerging about allowing the development of generative AI, and maybe we really regulate it after that, but we allow it to happen. And they tell this kind of little happy story, and I'm going, oh, that's a happy story. I'm not sure I really believe that, because there are going to definitely be divergences, and obviously the UK is talking seriously about not adopting the EU's approach to this, and how is that going to affect the development of industries? Well, I think, again, I hope this isn't offensive, most Americans think the AI Act is terrible, okay? It's just terrible. And they're going to think that the UK is terrible too. Now, one of the things that's going to happen if generative AI defenses, fair use defenses, are not successful in the US, what's going to happen? The AI industry will go to wherever the law is the most favorable, because it's a kind of industry that, especially now that the compute requirements are not quite as big as they were before, it's movable, right? The talent is movable. And so that's why Trump is going to be like thumb on the scale here, trying to protect the U.S. global advantage in AI, period, and in generative AI in particular. So, so I think the U.S. is still driving that bus, but EU has basically said, no! UK, no! And so we'll see what happens. But, I mean, if I was advising somebody, and I'm not, okay, but if I was advising somebody about whether to comply with the AI Act, I'd say no, don't. Develop your stuff, get it big, and when you get big enough, then you can do it, right? Because this creates entry barriers that are really significant, and startups basically won't come. I'm just so we're clear, okay, they won't come here to do it if they can't, if they don't have some privileges that will allow them at least to develop. Now, Martin has an idea about let's tax them once they actually get to the point where they're commercially successful, and then use some of that funding to support human authorship. And I think that's a very interesting idea, but we're quite a ways from a consensus about that.
Well, as much as I'm amused to listen to a lot of professors talk about AI, I think I'm more interested in the next slide that you haven't put on the slide yet, which is that as much as Gen AI is really the important thing right now about the fair use thing and all that training data, we are about to have a revolution in AI, we're going to have a recap of the whole SES WPL thing, because right now there's 4 key players who basically are the platform companies, you know, OpenAI, Anthropic, Google, and Microsoft, I mean, and Meta with their platforms, you know, ChatGPT, Llama, Gemini, and Claude, whatever it is. There are hundreds of startups building AI agent companies on top of that stuff, okay? And within a year, all the value in AI is going to be in the AI agents, and screw the LLMs. Those are going to be just like a platform, like electricity. You're going to see these massive losses coming from the platform companies saying, you got to give us up. You're going to share the whole ship. We're going to go back to WPL and SAP again, and the whole fairies thing is going to be irrelevant. It's going to be all about, can you use my platform and also, that's really the issue. So react to that.
Say versus accolade all over.
Exactly. And the fairy stuff is going to be irrelevant. It's all about agents and APIs.
Thank you, Bob.
I know a lot of these companies that I work with, the AI startups in the San Francisco Bay Area. I know what's going on. This is, the tsunami is coming, honey. Sorry. Please answer. Yeah.
It's a hard act to follow.
I'm still thinking about, is it a sensible policy to design our copyright to keep Elon Musk out of the country? So I was just thinking about the stories you were telling about kind of some of the spurious arguments and the gamesmanship that you kind of experienced along the way. And I guess the question is, what are some of the most specious arguments or kind of gamesmanship that you see coming out of the Gen AI debate now? As in, what are the specific things you see that we should all be aware of and be kind of vigilant about going forward?
Yeah, so I think that's a good question. And so from the standpoint of the plaintiffs, some of them basically say, oh, these generative AI systems, they're just collage machines. Okay, so they're trying to sort of plant the metaphor of collage machine, taking expression from here and here and here and here and here, and I'm just assembling them, and there's nothing creative about it. And also the sort of the stochastic parrot. That metaphor mean anything? Okay, stochastic parrot is basically whatever it is that I ingested, I'm going to throw up, right? That's actually, so I'm just a parrot, and blah, 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 blah. I'm not doing anything unusual or interesting or whatever. Okay, so those are metaphors that are on that side. The kind of the generative AI companies want to say, oh, I'm just doing this mathematical representation, and things are arranged so differently, and I'm not memorizing anything, and blah, blah, blah. And then you have researchers basically saying, actually, here's some memorization, here's some memorization. And then the question is, well, even if there's some memorization and even if some outputs include some memorization, how much memorization does it take to taint the system? And also, you know, again, the question about whether, if I'm an individual user and I prompt a generative AI system to produce some output, if that output is a copy or arguably a copy of some input, is that necessarily an infringement? Now, maybe in Europe it is, okay, but if I'm just a little, you know, teenager and I'm using it to like create an image and I'm just like playing with it, and I don't disseminate it, and I don't try to commercialize it. In the US, that would not be, that might be a prima facie infringement, but it wouldn't necessarily be an infringement. And we have a doctrine that goes back to 1985, which is that if a technology has substantial non-infringing uses, even if some people use it for infringing purposes, that doesn't mean that the technology is unlawful. So that Sony Betamax safe harbor for technologies with substantial non-infringing uses, that's a metaphor that the defendants in these cases really like. So I think that's an example, but I actually wrote a paper, co-authored a paper with a computer scientist named Joshua Block. Joshua Block was one of the key Java API developers in the Android project that was the subject of the Oracle v. Google litigation. And we both got really angry because the lawyer who represented Oracle kept using metaphors and shaping the argument in ways that was completely misleading. So, example is the term for what Google was using is declarations, right? The declarations are an interface between the method calls and the implementing code, right? That's why they're an interface, right? The lawyer at the appellate court level decided, I'm going to call it declaring code. And if I call it declaring code, then it makes it look like it's a literal infringement. So the case had been litigated at the trial court level as a non-literal infringement case. And by changing the terminology and using the term declaring code, it makes it seem like, oh, that's a computer program itself. Each of the declarations is a computer program, and therefore, literal infringement as well as non-literal infringement. And that was just bogus, okay? There is no such thing as declaring code. That's not what anybody in the technology industry would call it. And so the fact that they got away with it and that the Supreme Court opinion uses the declaring code thing, it just makes my blood boil. And so we wrote this paper about 14 misconceptions about software in the Google versus Oracle case. And this is the kind of thing, you know, this SSO thing basically is like a terminology that encompasses so many things, most of which are unprotectable by copyright law. And, you know, but that SSO metaphor, oh God. You know, the IBM people thought that one up, and, you know, that metaphor is really powerful. And every software copyright case tries to use the SSO thing. Look and feel died out, by the way, but SSO is still out there.
Okay, we have a exactly, last question. Time just for last questions.
I'm going to abuse my privilege because I'm holding a microphone anyway. Thank you, Pam, for that wonderful lecture. One thing that's been on my mind, going back to the point that Martin S. made, we've got so many Martins tonight, is that in the early 90s, the software industry, what we might now call the tech industry, was very pro-protection, and now they're more pro-freedom. But there is an interesting aspect to this in which it strikes me that a lot of these companies are very pro-trade secrets. And so when authors or musicians' organizations are saying to some of these AI companies, well, have you trained your LLMs using our works? And the company's response is, that's none of your business. And, you know, can we have a look inside your black box to see if you have been using our works without our permission? Their response is, no, of course you can't. That's our proprietary database. That's our trade secrets. So there is a protection argument being made. It's just not being made necessarily using copyright law. So I just wondered whether you had any thoughts about whether you think that argument still has some legs to run, whether it will actually play out in court, and just generally what your thoughts are.
So it's pretty clear that the European policymakers are intent on getting meaningful disclosure about uses of works as training data. But, you know, if you trained on 5 to 7 billion works, do you really want a list of all of those things which would go on for, like, you'd have to, like, you know, the city of London would be flooded with the paper, okay? So the question is, what is a meaningful way of having some disclosure, which gives the companies some flexibility, but also sort of provides some data that could be useful. Now, I'm happy to be out of that particular debate, but it does seem to me that there's going to be a push for granularity down to the work itself, each work, and I just think that's silly. What kind of compromise will be reached remains to be seen, but if you think that just because you say there's got to be some disclosure about training data, that you're going to get it on a work-by-work basis, so each copyright owner can like sue individually, I think that's just crazy. So, California legislature passed a similar law, and I think you might have seen in the paper today that a bill was introduced in Congress by some Republicans, basically saying states can't pass laws about AI for 10 years. It's like, really? So that's not going to fly either. But I think you can understand that just as in the EU and other parts of the world, you don't want every country to have, and every state to have, a different regulation, because if you want to have an industry, there has to be some certainty and some ability to sort of say, I'm in compliance. So a lot of energy is going right now into trying to articulate what would a reasonable opt-out regime look like. That's another way of kind of dealing with, I don't want my stuff done. But there is a way in which, you don't want anybody to learn anything from your work. Really? Okay, so that's kind of an answer. As in, they're not going to give up the trade secret, so there'll be some disclosure, but not as much as the copyright industry wants.
And what do you think a US court will do if faced with that, copyright on the authors on one side, trade secret holders on the other?
Look, with software, we've been dealing with that for decades, right? Every software company that has not used open source for all of its software, they all claim trade secrets as well as copyrights, and we've learned to live with it. I mean, I actually think that one way of kind of thinking about it that doesn't make me crazy is layers, right? So there's a layer that trade secrecy protects, and there's a layer that copyright protects, and then there's a layer occasionally that patents might protect. And then there's some things that are just plain in the public domain, right? And so if you kind of think about it as layered protection, it doesn't make you quite as crazy. But of course, when you get broad protection with copyright, you can end up essentially using copyright to protect trade secrets. That was why the decompilation thing was such a big deal, was because they were trying to use copyright to protect trade secrets, and that's not copyright's job.
Okay,
Thank you very much.
those were the last words. Thank you so much, everyone. Thank you, Ben.